Let's start. First thing is to know, and I think we probably let everybody know this, but this does qualify for Law Society credits, substantive credits, and depending on the topic and the week, professionalism as well. Um, what we're talking about today is guardianship of minors. It's often the roadblock to so many of our clients who, that is the part that they cannot agree with their spouse on. What happens if both of them are gone, and who's going to look after the kids? It's helpful, obviously, to know, first of all, what the law is, and then we can go from there on the planning side of things. So under the Children's Law Reform Act, that's the statute that governs this. A person with custody has authority to appoint a guardian for that child, for that minor. And a minor is someone under the age of 18. So as soon as they turn 18, they're an adult, and you can't have a guardian appointed for them unless they're mentally incapable, and then it's a whole different regime. But by definition, a minor is incapable. And so they cannot contract, they can't deal with their assets, and no third party can necessarily rely on them. We have this provision that one can put in their will to appoint sort of a person or two people, maybe multiple people, to discharge two main duties. The first duty is what I call the parental duty, or the custody. That is decision-making, personal care decision-making about education, medical care, where they're going to live, how they're going to be raised, all of those things, the things that a parent typically has authority over. And then the second component is this idea of guardian of property. So a minor, as I said, can't really deal with their property. They can own property, they just can't really deal with it. And so this idea is that the person also becomes in charge of managing that minor's property that actually belongs to the minor. So those two sort of roles, and they're often combined. That is the most common sort of situation. So let me just show you on eState, first of all, how we go about dealing with that. And so we've got Jonathan and Sarah, and they have two kids. It's helpful to put in the ages, because that way eState will know whether there are children who need guardians, etc. Just helpful, but you don't have to. I mean, you can always just ignore that if you want to. The more data you put in, the better. But we've got two minors here. And as we go through with our client, Jonathan and Sarah, we're going to ask them about who do you want to appoint as guardians. And they start saying things like, well, I want my sister. No, I want my brother. So you get into that discussion, and maybe we'll talk about that for a moment before we get into the sort of the nitty gritty. So under the Children's Law Reform Act, there is only the ability, and I think maybe I'll just try to call that up right now, Children's Law Reform Act. And there's a provision about testamentary, we want this. Testamentary provisions for guardianship. And so we're just going to I'm just going to scroll down into the section that's applicable so that you can see that. And in the meantime, I'll just shrink my screen a little bit. Here's where we've got, I'm just going to go to that. But the Act says that basically the person with custody has the authority to appoint a temporary guardian in their will. And that guardianship is only valid for 90 days. So that's really the limit on that. And sometimes I use that to just sort of keep the clients calmer about this decision, because here it is, section 61. Because often, as I said, it's such an emotional, they can't imagine anyone, no one can imagine someone else raising your kids. And so it becomes a very emotional thing, and often holds up the whole thing. Sometimes when they know that it's only valid, they only have the power to appoint somebody for 90 days, that makes it an easier decision for them. Sometimes it makes it harder. But this is the provision. So 61 says a person entitled to custody of a child. So that's a parent typically, unless there's some sort of order that says this person is not entitled to custody, can appoint one or more persons to have custody of the child after death. And the guardian may appoint one or more persons to be the guardian of property after death. We often just throw that in. So really what you're giving is the custody away, because a parent is not automatically a guardian of property of a child. They need a court application for that. Often we just say, I appoint so-and-so to have custody and to be the guardian of property for the child, even though maybe that's not technically possible, because as I said, unless the parent has gone out and got an order that they're the guardian of property, they're not automatically the guardian of property for their own kid. So, so that's the point there. And it's basically, this is the provision of this, but you'll see really it expires 90 days after death. And so what happens is that the guardian who's appointed as the temporary guardian in the will typically would go to the court and get confirmed as the permanent guardian, but the court could reject that, right? The reason the legislation is drafted this way is to ensure that the person who does have custody, that it's in the best interest of the child to have that person have custody. And the court retains the parens patriae jurisdiction, the jurisdiction over minors, to make sure that this person is a proper person. And that's why the ultimate decision rests with the court. But that's the statutory provision for the appointment in the will. I've never seen a court reject what the parents have selected as the person for custody, but presumably, you know, if that person's in jail or there are very good reasons why that person shouldn't act, then the court would intercede. If the advice I would typically give, if the client is concerned, look, what do you mean a judge can overrule what I want? I would encourage the client to write a letter and outline the reasons for picking that person. And if they anticipate a fight, you know, why you've picked this person and not that person. Because a court would really, I think, have trouble with overturning what a parent's decision was unless there's really good evidence. And if it's been thought through and considered, then I think that even makes the case stronger. So that's the point there. So then if we get back to estate planner for a second and how we do that, on the appointments tab, there's a section for guardians, and you would appoint the guardians in the same manner that you would do executors, trustees. It's basically the same thing, primary, and then if the primary can't act, then an alternate if you want to do that. So it's quite straightforward. And then I just want to take you through the kind of language that is generated by estate for the guardianship as a default. And of course, you can always change it manually if the client has something further that they want to add. But what we added were the things that we thought were important to at least consider. Oops, sorry. So here's the will that I've just generated. And oops. So I'm just going to make it a little bit bigger so we can go like this. So it's at the end of the will is the guardianship clause. So the way we've done it is we've said, look, first of all, obviously a child has to be under the age of majority. That's the first test for for appointing somebody. And the second thing is that you have to have authority to appoint a guardian. So if your spouse is alive and they're the parent and they have custody, they're going to have custody. You can't really appoint a guardian or a custodian for your child who's not the other parent, as long as they haven't, their custody hasn't been restricted. So this is only if you have authority to appoint a guardian for that person. And if those two are met, then you're appointing Mary to have custody and act as the guardian. And we put in this clause about, and maybe I'll just blow it up just so you can see it a little better, this idea that it's your wish that they apply within 90 days to be appointed as the permanent guardian. And furthermore, that the cost should be paid from the estate and not by that guardian. Furthermore, that there be no bond, but that the cost of any bond that is required be paid by the estate. So that the guardian doesn't have to worry about the legal fees and going to the court and doing this. And then we have the alternate appointment, which is very similar. And then we have these sort of standard guidance clauses. So these should be tailored for the particular client, or discussed with them anyway, to see if they're comfortable with them. But basically, the first thing is that we don't want the guardian to be out of pocket. So we want to make sure that they can, that they're compensated, that they're reimbursed, I guess, for expenses that are reasonably incurred by the guardian in providing a home for the child, and deeming that to be for the benefit of the child. The reason we have that deeming it for the benefit of the child, we don't want the children's lawyer's office to say, you made a payment to the guardian and that is not the child, and we think that's an improper payment. It's unlikely, but this just makes it even clearer that this is for the benefit of the child. And then we have a further clause that talks about advancing funds for additional living costs, entertainment, reasonable payments for enlarging the home, loan to the guardian if they so feel is appropriate, that is the trustees, or given outright to the guardian, and again deemed for the benefit of the child. And obviously, the last clause is something that just says, look, really what's important here is that the best interest of my child and my desire that they provide a happy home life, and place emphasis on the financial needs of the child and potentially the guardian in raising the child. And then if estate sees that you have more than one child, it will add this clause. If you only had one child, it wouldn't put in this clause. So another reason why sort of estate is sort of thinking ahead and making sure that it's consistent. So that's that. Now, the other thing is, this might be an area where the client wants to add further provisions. And you may want to put it in the will, but often I say, write a letter to your guardians and to your trustees saying, like, these are the things that are important to me: religious upbringing, or, type of schooling, or, I would encourage you to let my kids travel, or whatever it might be. The more guidance you give, the better. So that's sort of my discussion on the idea of guardianships, and I open the floor really now to anybody who has comments about how they deal with their clients with respect to guardianships. Any tips that people have. So please feel free to jump in. And anybody? Anybody else find this a problem with clients, that it's often the sticking point, right? Maybe, I don't know if everybody is muted or just, okay. Thanks, Mallory. Let me just see if I can get Zoom to, let's just go participants here. I think everybody's unmuted, according to this. Okay, anybody have, well, there's a chat here. Is there a sample letter? I don't have a sample letter, actually. I sort of I just sort of give them things to think about. I don't really have a sample letter that I give. Anybody have a sample letter or use any other techniques for that? No.
Jordan, I had a question.
Sure.
You had said that typically the person who has custody and the person with guardian of property tends to be the same. Lately in our office, we've had some wills coming in for litigation reasons, not having to do with the custody at all. But I had noticed that in all of those, it was two different people. So say it was like the kid's aunt and uncle were chosen for custody on like one side of the family, but then the person dealing with the property or handling the trust, since the kids are underage, is from someone else on the other side. Do you think from like a shall we say, a collaborative cooperation standpoint, that that's kind of a smart thing to do, to sort of involve all sides of the family in an equal way almost?
Great point. And let me clarify something here. When you see the term guardian of the property, that is not the same as the trustee of the trust for the child in the will. Because the trustee of the trust, they're the ones who are going to decide how much to give to the child and how much to give to the guardian, and the discretion there. That's different. The guardian of property is if, for example, the child has a house, okay, in their name and they're a minor. It's not held by the trust. It's actually, their name is on title. Now you need a guardian of property because somebody's got to manage that asset. So it's an asset that's not in the trust. It's an asset that's literally in the name of the minor. And that's a distinction between a guardian. That's why guardians of property are not commonly seen for minors. Instead, there's a trust that's being managed by the trustee and deciding money, flowing out to the guardian before they're 18. They wouldn't necessarily give it to the kid directly. So I just want to make that point. The second point is a great question, which is, and clients ask this all the time, should I split up those two roles? Should I split up the custody and the decision-making on how much money comes out of the trust to flow out to or for the benefit of the child? And again, if there was always a perfect solution, our job would be really easy. There's always two sides to this. I mean, one is if you trust, my little spiel is, look, if you trust, one argument is if you trust a kid, trust this person with custody and making, medical decisions for your kid, you probably can trust them with the money. The other option is, do you want to burden this person not only with one job, but with both jobs? Do you want to split those so that you're spreading the burden a little bit more? Do you think that person who might be the perfect alternate parent, as it were, parental decision-making, might not be a good person for managing the money or making those kinds of decisions? So there, I think it's important to sort of describe those two roles to the client and then say, what do you think about that? Obviously, the more people you involve, the more people, logistically, it's more difficult. If there's a different trustee than the guardian, then they have to get along, right? So, what you might want to make sure is that that the trustee and the guardian are going to get along, so that the guardian is going to get enough money for them to live on, and there's not going to be this tension between them. So, and then there's the whole check and balance, the idea that, well, with one person in there, maybe there's not as much of a check and balance. The children's lawyer's office is involved whenever there's a minor who has an interest in an estate, and they keep a pretty close eye on things and require passing of accounts from time to time. So, that would be my general. It doesn't, I wish there was a simple answer, but that I think is the discussion that it should entail when thinking about these options.
Thanks.
Does that make sense, Mallory?
Yeah, it did. I had never heard the term guardian of property in this context, so that's why I was definitely confused. And as you said, it's rare, so that's probably why I was definitely lost there. But that makes a lot more sense now. Yeah.
So the guardian of property, as I said before, the parent is not. I'm not the guardian of property for my children's property. They're my children. I'm not the guardian. If I want to be the guardian, I'd have to apply to the court. So interesting. It's something that, so that's why it's not the same as the trustee, which is much more common, obviously.
Right, yeah. Thank you.
Yep. Anything else?
So Jordy.
Yeah.
So in the similar light as the question that was kind of asked is that obviously in the single parent family situations, you may find quite often that a beneficiary designation would have been a minor. And they would have possibly put a trustee or not, okay, like an RRSP, let's take that as an example. So how would that fit in under the guardianship of property or not, if that was the type of scenario you were dealing with and planning for?
Yeah, I mean, that's where we see a guardianship of property. The two classic cases of guardianship of property are, so let me back up for a second. If a minor is entitled to money with no trust at all, that money, and there's no power to hold it in the will, there's no trust established, that money has to be paid into court by the executor, okay? They can't pay it to the guard unless there's some provision in the will, but they can't, it has to be paid into court. That's the only way that the trustee or the executor, let's use that term, the only way the executor can get a discharge for that money, unless the will says something different, is to pay that money into court. So, so then the money gets paid into court. Let's say it's an RSP that they're the named beneficiary and there's no other provision, gets paid into court. So the court will hold that money till they're 18 and then turn it over. The other option is this guardianship of property. What we see sometimes is that the parent then applies to be the guardian of property for that child and then takes the money out of court and now is in charge of the money for the minor. But that requires a court application. So that's where you see a guardianship of property, where property, for whatever reason, vested in the child before they were 18, therefore has to be paid into court because there's no other alternative because of whatever was drafted or however they became entitled to that money. And now the parent says, well, I don't really want this money sitting with the court. They're investing it, but they're not investing it the way I'd want it. And so that's where we see these guardianship of minors. And the other, classic case, personal injury accidents where there's payments that the minor is entitled to. That's where you see guardianship of minors. Those are the classic sort of situations. Somehow the minor became legally entitled to this property, not held in trust, and we need somebody in charge of it, or else it goes into the court.
So that would be a structured settlement, possibly as a scenario as well. But
a personal injury for a minor, there's a structured settlement, but the minor is entitled. That money is going to the minor. It's not going to a trustee. It goes to the minor. Now you need a guardian for that minor to collect that payment and deal with it. So that's a classic guardianship of property situation. Hope that helps. Other questions? Anybody else? Any other questions on guardianships or for minors or custody?
Jordy.
Yeah.
I've got one. It's a little bit, it's sort of related, but a little bit off. I recently had a fella ask me to do a will for him. He has a minor child. He's not married, but he now has sort of the live-in girlfriend. They've been together for about a year. His entire estate is about $15,000, 1-5, okay?
Yes.
And he said, I'd like to leave it to my girlfriend. And I'm thinking, well, that sounds problematic because shouldn't you be leaving it to take care of your child? But then I thought, well, but if he's living with the girlfriend, does she have potentially a support claim if she's a dependent on him also? And I'm thinking, what do you do with something like that? I mean, the little ones are the worst ones, right?
Well, I can solve that guy's problem because my fee for that would be $15,000, and now there's a problem, right? Because he has nothing. But seriously, sorry.
Yeah.
I mean, you can pay. Let me make another point. That brings up another point. An amount less than $10,000, I think, or is it 10,000 and less? I always get that wrong, but $10,000 or less, let's say, can be paid to the parent of a child without needing a guardian of property. Okay, so if you're going to give money to a minor and it's less than $10,000, you don't have to pay it into court. You can pay it to a parent or guardian. So that's the first thing. So as long as the amount is less than 10, you're okay. If it's 15, look, I mean, that's one I'm not sure I would worry that much about. I mean, for 15 grand, who's going to get a lawyer to deal with this whole thing? I mean, and the girlfriend, it doesn't sound like a common law spouse. If she was, she'd have a dependent court claim. If she's not, but yeah, I mean, that's, I mean.
Yeah. Well, and the reason I bring it up is because when you mentioned the children's lawyer, so if the will gets, he dies, will gets probated, it goes off to the children's lawyer, and the minor child is getting nothing.
Right.
And okay, what are they going to say?
Right. No, they're not going to know about it, because they only get notice if the child's a beneficiary. They don't get notice if a child is not a beneficiary and is cut out.
Okay. All right. That could solve the problem.
Yeah.
Okay.
Otherwise, we'd have to serve the children's lawyer every time. But if you don't, the child is not a beneficiary. If a minor is not a beneficiary or potential beneficiary, then they don't get notice. Right. So.
Right.
I would guess if there were support obligations, there might be some issues, right, Jordy?
Well, for 15 grand.
Yeah. Yeah, I guess. Yeah.
I mean, but yes, if we were talking about an estate that had hundreds of thousands of dollars, yes, the girlfriend might say, I'm a spouse. The child would have to have a litigation guardian, and we'd be off to the races. But yeah, for that one, I mean, yeah.
Yeah, exactly.
Shannon, did you have a question?
Yeah, question for you. Have you ever been in a scenario, so we got a split family. I don't think that custody was ever taken away from one of the parents, but has had nothing to do with the child's life, and the parent would still like to include their wishes, even though I've been very clear that a person with custody, isn't, you're not going to get away from mom or dad if they haven't been denied their custodial rights.
Right.
Would you still, for the sake of argument, throw in there?
Absolutely, because that parent may predecease that other parent, and I mean, either if you have authority, great, then you can do it. If you don't have authority, too bad, you just ignore it. It's like saying, I give the Eiffel Tower to John. I mean, if I don't own the Eiffel Tower, then it doesn't really matter. If I do, John gets it.
Yeah,
I would have no problem at all doing that, and I would regularly do that with separated spouses. I would absolutely. I have no idea who's going to die first. So
yeah, I'm not so worried about the who's dying first. They're saying to me, even if that former spouse of mine is still living, I want language in there as to why I don't think the court should choose that individual.
Yeah, I'd put it in. I mean, obviously with the warning that it's not binding on anybody.
Right.
Potentially. Yeah, but I think I would have no problem putting that in.
Okay, thanks.
Yeah. So we're coming up to 1 o'clock. Any other questions?
Can we talk about resulting trusts that we had some conversations on previously?
Hang on 1 second.
Okay. All right.
Yeah, no problem. I just want to see if anybody has anything else that they want to raise on about minor guardianship.
The only other question was when you have a scenario, so dealing with a scenario where the financial institution holding a pretty significant registered plan has suggested to the client that, oh yes, you might want to include your minor beneficiary as the contingent. And you can address that by way of will so that it does get paid out to them, not to the court. And I'm thinking, okay, what am I missing?
Well, there's this provision for an annuity payment for a minor. I don't like it because the whole thing gets paid out by 18. So right. It's not, that's one. I mean, are we talking about a $4 million RSP?
Yeah, not even.
Yeah. Okay. I would say to the client, do you really want your kid getting this money at 18? Regardless of it's so big that you're worried about probate fees.
Right.
but then I would definitely be so worried that they're getting it at 18.
Right.
So it's like they go hand in hand. Like, oh yeah, we're going to save probate fees. Yeah, well, the kid's going to end up with an RSP of $3 million at 18.
Okay.
So that's where we have to, use some common sense.
Right. But I wasn't missing something, that there is some way that I can direct in the will that it gets paid to somebody in trust with kid.
You could do it. There's an argument, although the Succession Law Reform Act doesn't specifically allow a trustee, right? It's not uncommon. I've seen it. I've done it myself, to say it's so large that I'm going to pay that. I'm going to have that RSP paid to John Smith as trustee to deal with sort of the same way we do with a life insurance policy. Right. And, I've never seen anybody, I mean, as far as the bank cares, the designation would seem, okay, it's going to John Smith, here you go. I mean, as long as you can, you trust John Smith and you have that provision in there that he's receiving it as a trustee and those kinds of things. I certainly have seen it done. And I've never seen, anybody, aside from people raising, oh, but it's different because the SLRA doesn't have the same language as the Insurance Act. It's true, but any property I think you can give to anyone else in trust. I mean, maybe the beneficiary designation doesn't say as trustee, but the terms of the trust are he gets it in trust to hold, right? So.
Okay, thanks.